All right. Good afternoon, everyone. My name is Evan Seaman, and I am a land use lawyer at Robinson and Cole in Hartford. But more importantly, I am a co-chair of the Connecticut chapter of the American Planning Association's Program Committee. And I'd like to welcome you all to today's program, an overview of Southern New England and national land use law developments. This program is in partnership with both Massachusetts and Rhode Island chapters of the APA. And important for many of you, it's eligible for one CM law credit. So make sure you log those credits after today. And then one last thing to note, if you do have questions, there's a little Q&A button at the bottom of the Zoom screen here. You can type your questions there and we can answer, the panel can answer them as we go along, either live or in writing. With that, Dwight, why don't I turn it over to you and we can get this thing started.
Thank you very much, Evan, and welcome everybody. It looks like we've got 280 of our closest friends with us today. Our speakers, as you can see here on the panel, include Marjorie Shansky from New Haven, Connecticut. And from Massachusetts, we have Pamela Brown, who's a fellow of the American Institute of Certified Planners, and Greg McGregor. And then from Rhode Island, Michael Vigneault. And we have a 1-hour presentation, and I'd like to start now with an overview of what's going on in the world of exactions. Exactions include, as you know, things like open space set-asides, requirements that developers provide in kind certain facilities. And now we're seeing more inclusionary zoning of a mandatory percentage of affordable dwellings. A case by the US Supreme Court last year called Sheets promises to cause us a lot of issues going forward. And I want to give you a foundation for understanding Sheets and a quick view of Sheets, and then let you contemplate what happens next. We're going to send you some materials probably tomorrow that you see here today. We've got a lot of background. So starting here with laying the foundation, I think of Wizard of Oz, the Wizard of Oz being the yellow brick road, lions and tigers and bears. Well, if you join me in saying Nolan, Dolan, Kuntz, oh my, Nolan, Dolan, Kuntz, oh my, that's all you need to know about the Supreme Court precedents in exactions. Nolan is about the qualitative connections between exactions and what the government can require. Dolan was about how much you take and how far you can go. And Kuntz extended Nolan and Dolan to cash payments, like money payments in lieu. Nolan was a case in which this little cottage was going to be torn down along this beachfront by Patrick Nolan. There's the house he eventually built. And there's the house there today in Ventura Beach. And what happened was that the California Coastal Commission had the right to require a visual access down from the street to the water, but instead they asked for more. They told Nolan, we want an easement along the side of your house and along the beach. The question was, did the statute allow them to go that far? Was there an essential nexus between what the statute allowed and what they were asking for? And the court said that a lack of the nexus between the condition of approval for that reconstruction and the original purpose of the building restriction to allow visual access wasn't there. And unless it serves the same government purpose as the statute allows, you can't do it. There's the house today. Nolan died a couple of years ago. That little beach cottage became a $2.25 million house. Then along comes Florence Dolan. Florence Dolan in Tigard, Washington. There's, by her store, a walkway along Fano Creek. And there's Fano Creek where there had been a bike path and a pedestrian path, but nothing that passed her plumbing supply place. So when she came in to expand the store, and this is the way it was eventually built out, the government said, look, you're causing traffic impacts. You got to provide a bike path to mitigate the impacts. When we saw that, a bunch of us said, wait a minute, how can that be? And Scalia, during the oral argument, it's worth reading, said, I've lived in Washington. I go to the parks. I don't see anybody on a bicycle with a bathtub on the back. Don't tell me that this is fair exaction for offsetting the impacts of traffic. And there's the store as it was built, and there's the Fano Creek Trail along the side. On the day of the argument, Mrs. Dolan sat right here in the reserve seats. Chief Justice Rehnquist gave her one of the reserve seats so she could be there at the argument. And so while the Nolan case talked about the essential nexus, the connection, the qualitative part, the Dolan case said, is this asking too much? Is it roughly proportional to the traffic impacts from a plumbing supply place? You have to have rough proportionality. You have to have a quantitative connection. So in both of these cases, look at here, individualized treatment. Nolan and Dolan were one-off, ad hoc, site-specific exactions, negotiated, imposed for physical invasion. And they set that standard of essential nexus and rough proportionality. And that's where we were until the next case came along. Incidentally, here's the pathway is completed. And Florence Dolan demanded, because she won, in settlement that they put a plaque up in her honor. So if you go there today, you'll see that John and Florence Dolan, they won the case. They also won some money. Here's Florence in her younger days, the time of the case. And I love this up here. Look at this, everybody, all you planners. When this case first started, and I was at the oral argument, I was did a little interview on television about it too, but my first reaction was, look at this thing. That's the way they beat the sign regulations. They put a trailer truck with the name of their business out there. Anyway, they're fun. The business, that was when it was built. Now it's out of business. Then along comes Kuntz. This is Coy Kuntz Jr. His father started this case. This was 11 years ago. We gave him a national award for his perseverance and his father's. And their property is down here in Florida along the St. Johns River Management District. And this is what it looks like. And here's their property along the state highway, a little bit of upland here, a little bit of upland here, the rest of it wetlands. And he just wanted to build something there. And this is a little better diagram of what was upland and what wasn't. There's uplands, maybe 13 acres of wetlands and 3 acres of uplands, particularly up there. Remember this, because I get on this case a little more, about 6, 7 miles away. Here's the site. And way up here, there's some improvements needed to be made, unrelated to his project, except they were, in a way, physically connected by this little tributary. So what he had, almost 15 acres on a major highway, but he needed this thing here, a wetlands resource management permit. So he said, I'll give you 11 acres and let me build on 3. And the management district says, no. You can have an acre and give us an easement on 13.9. Or if you want to develop 3.7, you're going to have to pay for this improvement up here, miles from your project, money out of your pocket. So Kuntz said no, off they went, ended up in the Supreme Court. And the important precedent in this case was Nolan and Dolan, physical exactions, letting people come on their property. Kuntz was money, like money payments in lieu of, cash payments, connection payments, all of the stuff that we do routinely with exactions that involve money. And the court said Nolan, Dolan, essential nexus, and roughly proportional counts with money. That's where we were when Sheets came along. And so now Nolan Dolan applies to these things. We don't really in these 3 states have much in terms of what we would characterize as impact fees, but we got lots of other types of fees and mitigation approaches. This was what was eventually built on his 3 acres. Along comes Sheets last year. George Sheets, double wide manufactured house, modest home. And the county in which he was located had a legislative fee, not a site specific like Nolan, Dolan, Kuntz, but a legislative applies to everything boilerplate fee for traffic mitigation. And that's what was imposed on him, and that's what was in this case. The fee was $23,420 for that modest home, legislatively adopted. The U.S. Supreme Court, this is the holding, which is so important to us here in Southern New England, that these legislative exactions are now subject to Nolan, Dolan, Kuntz. Essential nexus in the qualitative sense, quantitative nexus in that sense, in terms of the amount. It went back on remand. The court upheld the fee. I think it was a failure of evidence in the case, but they did. And now look down here, you'll get these materials. There's the Sheets case on remand. Where does it stop? And this is where I'll stop. Open space dedications, landscaping, parking, connection fees, and now in the city and county of Denver, a lawsuit challenging mandatory percentage of moderate price dwellings. Take it away, Greg McGregor from Boston. And I will unshare here as soon as I figure out how to do it.
Up at the top.
Yeah, I got it. Take it away, Greg.
Thank you. Thank you very much for this invitation, Dwight. You now know, courtesy of Dwight, that there's been a string of cases telling us in more and more detail as the Supreme Court is willing to delve deeper and deeper into the nighttime hearings of our New England boards. How much connection is enough? What substantive nexus must there be? It extends it to trying to hold someone up for money, often called exaction, sometimes called extortion, depending who point of view you have. And now reaching out to official, legislative, and probably administrative impact fees. My topic is, however, a single Supreme Court case of some note, because finally we have the culmination of the Trump administration's first and now resurrected administration approach to deregulating permitting at the federal level with a focus on the National Environmental Policy Act. We've lived with the act for more than 50 years, but this is my tagline. NEPA is no longer your uncle's National Environmental Policy Act. You have to relearn. Here's the context. On day one, Trump signed an executive order called Unleashing American Energy. You can understand the theme is to deregulate and reform permitting, including targeting NEPA. The order directed the Council on Environmental Quality in the White House, which is in charge of NEPA regulations until then, to change its regulations, in fact, rescind them, and let the individual federal agencies promulgate their own regulations to implement NEPA. Many federal agencies already had some NEPA regulations of their own fitting what they do or what they build or what they fund, but now you will be looking to the individual agencies you've been dealing with. Now, federal agencies have been ordered to speed up certain kinds of permitting and other approvals, like those of the EPA and the Corps, but especially those that are critical to the U.S. economy or national security. And then here's an editorial enjoinder. All federal permitters shall adhere to only the relevant legislative requirements for environmental considerations and shall strictly use the most robust methodologies of assessment at their disposal and shall not use methodologies that are arbitrary or ideologically motivated. End quote. Now, further as to context, remember what Biden had done just before Trump came in. CEQ had issued what it's called Phase 2 NEPA regulations, which dramatically reformed NEPA into much more than a procedural study at first law. Instead of a disclosure law, it would be a fundamental charter to protect the environment. And when you read the phase 2 rules that were going into effect and are now not in effect, you'd say this belongs in an environmental or land use planning course, the ideal. So NEPA would have been a planning tool. It would have dealt with environmental justice, communities, and climate change. It would have built ecosystem resilience. It would streamline and shorten the NEPA process, that's true. But the focus now would be a rigorous analysis of alternatives and an explanation of why the preferred alternative was chosen. There'd be specific attention to climate change, resiliency, tribal treaty rights, and environmental justice. And you'd have to consider alternatives that would minimize impacts on the human environment. You can now forget this slide. It's not the law. Trump told the CEQ, and now the CEQ has decided it's appropriate to remove its regulations from CFR. And with them, the baby and the bathwater. Every NEPA requirement since Nixon through the Biden administration, all the NEPA rules and CEQ guidelines are gone. And the Trump administration's CEQ policies are in, and as I already told you, each agency is responsible to create its own NEPA rules or guidances to which it will be subject. In other words, they asked the fox to write the rules for the henhouse. So all those CEQ rules and guidelines are gone, and we're waiting for the new rules, some of which have been promulgated in proposed form. They were mostly supposed to be there by July, but there are many more coming. Now, meanwhile, a case gets pending in the Supreme Court called Seven County Infrastructure Coalition versus Eagle County. The issue was, does NEPA require an agency to study environmental impacts beyond those that are reasonably foreseeable results of the agency action in which the agency has authority to regulate? Think upstream and downstream, direct, indirect, short-term, long-term. Does the agency have to go off the tracks to see what's next to the railroad tracks, left, right, and in front and in back? Here's the spoiler. The Supreme Court ruled no. And that's the remaining subject of my presentation. There it is on a slide. Supreme Court decision relaxes NEPA scope, we'll see how, and requires the courts defer to the agencies on the scope of NEPA and the particularities of the study, if any, and when they've studied enough. Well, isn't that interesting? We're now entering a new era of deference by the federal courts. So here's a citation. There you are. It's a big change, sea change, in how agencies comply with NEPA. It actually says it requires courts to grant, these are the words, substantial deference to agency decisions on the scope of their reviews, including length, content, level of detail. And in case you needed it, the ruling clarifies NEPA does not require agencies to go very far off the rails. They don't have to analyze the environmental effects of separate projects that are not in their purview. The language is that are distant in time or place from the action under review. And the ostensible reason for this is to speed up infrastructure permitting. I did not say strengthen environmental reviews and interdisciplinary analysis. I did not say that strengthened. On judicial deference, the court established these are words of the judges in a unanimous decision. The court should not micromanage agencies' NEPA analyses. What's the scope? Agencies don't need to analyze the effects of other projects that are separate in time or place. Many commentators said, what's this about causation? What's the Supreme Court talking about causation? The court found that the separate projects of oil drilling and refining as an indirect result of a railroad carrying petroleum lacked the necessary, quote, reasonably close causal relationship, unquote, to the railroad project, partly because the effects were too attenuated. How do you know that? Well, the court said so. And the agency lacked regulatory authority over those other projects.
1 minute, Gregor.
Thank you. One slide here that you'll get later is teed up the case to be what I said. The parties fought it out to the nth degree. And I point to the last quotation on this slide that in reviewing an EIS for being arbitrary or capricious, the court says the only role for a court is to confirm the agency has addressed environmental consequences and feasible alternatives, and it has to give that substantial discretion to the agency, which will be upheld. Here are the decision makers. It was unanimous, but for Gorsuch, who took no role. And these are the exact quotations you can give your clients. And there's the takeaway at the bottom. NEPA's scope in reviewing federal projects, funding, and approvals is now narrow. CEQ's regulatory role is diminished. The importance of individual agency rules is paramount. Federal courts reviewing NEPA compliance is constrained. And they are to afford the agencies considerable discretion. Thank you very much.
Thank you, Gregor. Right on time. And next up is Michael.
All right, I'm just sharing my screen here. Hi, everyone. I'm Michael Minot. I'm a partner at Partridge, Snow and Hahn in Providence. Today, we'll cover 4 recent Rhode Island court cases from the past year. The main themes with these cases are strict ordinance interpretation, zoning amendment procedure,
Hey, Michael,
standing.
we don't see your slides.
Oh,
Seeing
excuse me.
We're seeing your prompts.
Oh, whoops. Can you see the?
There you go. Rock and
All
roll.
right.
Rock and roll.
Sorry about that. So the first case involves a pre-existing substandard lot, which obviously is very common in Rhode Island and throughout New England. The nonconformities were lot size, frontage, and multiple setbacks due to the pre-existing structure. The homeowners here wanted to demolish their 1950s home and build a new home in the center of the lot. The new home actually would have been a bit smaller and a bit less non-conforming, but still required setback variances. So the homeowners applied for a dimensional variance to the zoning board after voluntarily demolishing the existing home. The board granted the variance, and then the neighbors appealed to Superior Court. That court affirmed the board's decision, and then the case went to the Supreme Court. And the issue on that appeal was whether the ordinance even allowed the board to grant the variances due to the voluntary demolition of the structure. And the Supreme Court vacated the judgment, finding that the plain language of the ordinance was key. And that ordinance language provides that when a non-conforming building is demolished or removed by or for its owner, it may not be rebuilt except in conformity with the dimensional requirements of this zoning ordinance. The only exception would be for destruction beyond the owner's control, which obviously was not the case here. And the decision emphasizes that courts shouldn't try to add language to an ordinance that were not included in the ordinance. And also the idea that conformity might include the ability to obtain a variance was rejected. The court reinforced that clear text must be applied literally, and also that courts should not search for ambiguity that isn't there. The takeaway is that voluntary demolition of a non-conforming structure can have significant consequences. And outside of Rhode Island, the important implication here is that if your ordinance does not expressly allow for reconstruction after voluntary demolition, then the right to rebuild a non-conforming structure may be lost. The second case we have is Koziol Firearms versus Marchand. This involved property in Central Falls, Rhode Island, originally purchased in the 80s. At that time, the property was in an industrial zone, and starting in 1990, the property was used as an auto repair business. And then in 1992, the city changed the zone from industrial to residential, which made the auto shop a pre-existing non-conforming use. Then in 2022, Koziol established a firearms business and applied for a use variance to operate both that business and the existing auto business at the site. The board denied that use variance request. And then Koziol challenged not only that denial, but also the validity of the zone change. And they claim that they never received proper notice of the zone change. The Supreme Court did not resolve the argument about the zone change or lack of notice. Instead, it focused on the process that played out in Superior Court. The lower court judge had dismissed a declaratory judgment claim based on a lack of evidence in the record and had not taken any additional evidence. And the Supreme Court held that it was the lower court's job to take additional evidence and conduct fact-finding. So the case was remanded for a full evidentiary hearing. A couple key takeaways here are that declaratory judgment actions require an independent factual record, and challenges to old zoning amendments can remain legally viable, at least potentially, if the record regarding notice or enactment is not clear. And regionally, outside of Rhode Island, the case highlights the importance of maintaining good records of zoning amendments and evidence of notice. And the third case is one I was actually involved in, not this particular case, but a related matter several years ago. This case involves a dispute between competing solar developers. Here, Revity Energy applied for master plan approval for a solar project on land owned by a different entity. After that hearing, the planning board granted the master plan approval. And then a competing developer, Green Development, appealed that decision. Green argued that Revity lacked site control because Green held exclusive contractual rights, and those rights were the subject of separate litigation. And the board held, and the Superior Court agreed that Green lacked standing. The court found that an aggrieved party must either be a property owner or be entitled to statutory notice, and that mere lessees do not enjoy a universal grant of standing. And here, Green did not own the property, nor was Green entitled to statutory notice. The court also found that even if notice had been required, Green fully participated in the appeal, thereby waiving any notice defect that may have existed. And two important takeaways here are that standing is a strict threshold requirement, and that participation in hearings cures most notice defects. And the broader takeaway is that courts will not allow a competitor to disrupt a project simply by pointing to competing contractual rights or disputes. And unless they have standing, the recourse is through private litigation, not administrative appeals. And the final case here, this was a U.S. District Court case out of the District of Rhode Island. This is SCLS Realty versus Town of Johnston. In this case, the town sought to take private property for an affordable housing project. The Rhode Island Superior Court had previously entered an order returning the property to the property owners, but the town failed to record that order and continued acting as if it had the authority to move forward with the project. The developer then filed suit in federal court and alleged due process violations. The judge issued a TRO after finding that even if the town had a legitimate public purpose, the Constitution required that lawful procedure be followed, namely the recording of that order. And the TRO ordered the town to record the Superior Court judgment and immediately stop all redevelopment actions until coming into compliance. And this case highlights an important principle, and that's that redevelopment, including affordable housing, must follow lawful procedures and not violate due process protections. And outside of Rhode Island, the broader significance is that affordable housing statutes do not insulate municipalities from constitutional review if there are potential due process violations. And finally, just a few final takeaways. These cases send a clear message that procedural compliance matters, and they also highlight the need for cities and towns to review and apply their ordinance text carefully and as written, maintain robust historical records, confirm standing, and also respect both the statutory procedures and constitutional due process requirements. And can't believe it, but I'm under my time by a minute or so. Didn't think that was going to happen, but thank you for your time. And feel free to reach out afterward if you have any questions or would like to discuss any of these cases further. Thank you.
You're very disciplined, Michael. You did a great job. Gregor, too. And I think what you'll see from these first three presentations is this panel, which has been together for a long time, is very careful to pick issues and cases. And Pam, you're up next, so you can tee up your presentation while I make a couple of comments. We are very careful to pick issues and cases of general interest across the states. And there's something to be learned from what's going on in our two neighbors. We also have a Q&A function on this, and we have one question. And Gregor, if you could do a 30-second answer. I think I know what the answer is, but here's the question. Connecticut has had wetlands laws that predate NEPA and has its own version of NEPA called SEPA. Will Connecticut wetlands survive the recent federal court decision?
Yes, it's not, yes, stop there.
Yeah.
Yes, it will survive because
And
it's a
that's in
federal
fact
case about a federal statute.
And to the extent, Gregor, that our states don't have a robust wetlands protection, they can add it now still, right?
Oh, yeah.
All right.
Yes,
so,
of course. The second half of the question is for a Connecticut lawyer dealing with federal preemption of Connecticut law. I'll defer.
Okay, so we do have that Q&A. Don't know how much time we'll have for that, but now here's a subject that is driving us all nuts. And Pamela, you've really picked, we did this presentation earlier to the Bar Association. You picked some great stuff here. So tell us about short-term rentals, will you?
Thank you. So you're right. I picked the fun ones. Short-term rentals have become popular with the entry of Airbnb and other online portals, allowing property owners to rent their homes or apartments as an option to traditional lodging in hotels and guest houses. According to research by the Commonwealth of Mass, the number of short-term rentals have continued to rise. And on the islands, in particular, Nantucket, Martha's Vineyard, the majority of housing stock is actually represented by vacation homes and seasonal rentals. Cape Cod and other waterfront locations, the mountains, tourist destinations, Newport, the Connecticut coast, have all seen an influx of homeowners and investors jumping into the short-term rental market, whether it's to help support their year-round living expenses or as a rental investment business. There are, of course, pros and cons associated with short-term rentals. Permanent residents complain of noise, traffic, parking, lights, the typical neighbor complaints. Landlords who want to maximize profit often inflate the reasonable use of the rental, as in the 2019 case that I actually reviewed several years ago called Slice of Life, which actually marketed a 5-bedroom home to accommodate 18. In that case, the Pennsylvania Supreme Court focused on the definition of a single housekeeping unit And the court opined that single-family use is more than just a group that maintains a single housekeeping unit, but one that is also non-transient. Prior decisions have surrounded the interpretation of local bylaws and their definitions, including the definition of household unit, as well as length of stay. Recently, as many of you may know, there's been contentious litigation on Nantucket. Catherine Ward, who's shown here in court, is an abutter to the Grape property, which is located on West Dover Street on Nantucket. She was bothered by the noise and lights of short-term rentals or renters and sought zoning enforcement, arguing that the short-term rentals were a commercial use. The building inspector disagreed, and Ward appealed to the ZBA, which confirmed that short-term rentals were an allowed use.
Pam, are you advancing your slides?
Oh dear. I have two screens. Slice of life. Okay, here we go. And you know, when I practice this, both screens turn. So sorry about that. In 2024, the land court noted that we called it Ward 1, that Nantucket's bylaw was one that prohibits use, which many of ours do. And you prohibit any use that's not specifically stated in the bylaw. And that the Nantucket zoning officials incorrectly concluded that the Grapes rentals between 2017 and 2021 were within the property's allowed principal use as a primary dwelling. So Nantucket has made several amendments to the bylaws over the years with provisions for accessory dwellings. I gotta move my things here. Rentals of over 30 days and rental of rooms within an owner-occupied home. But they had, maybe unintentionally, removed words that were previously contained in a 1972 zoning bylaw, in which the term use included or is intended, arranged, designed, built, altered, converted, rented, or leased to be used. The 1991 bylaw revised this definition to include only a use expressly permitted by the bylaw. And further, the zoning district containing the Grape property prohibited transient residential facilities. The case did not consider the history of short-term rentals on the island or the regulation of them, but as a sidebar, noted that both the plaintiff and defendants had summered for years in short-term rentals prior to their home purchases. The Ward 1 decision left open the possibility that short-term rentals might be allowed as an accessory use if it were found to be customarily incidental and subordinate to the principal residential use. And on remand to consider the issue, the Board of Appeals found that the Grapes short-term rental of the main house was a permissible accessory use, citing a traditional practice on the island. Ward, of course, appealed the decision back to the land court, leading to further hearings in early 2025. So in Ward 2, the land court considers whether short-term rentals were actually an accessory use. The accessory use section of the Nantucket bylaw was considered, and since 1991, the town had regulated accessory uses that were, again, subordinate and customarily incident to such permitted uses. This language is not unique, and the court actually cited two 20-year-old SJC cases from Mass and Connecticut. The references to those are in materials that'll be circulated. So this again is the definition of the principal use or accessory use in the Nantucket bylaw. But here the court determined that the private use was primary and the short-term rental subordinate, given the amount of time the property was actually used by the owners or vacant as compared to the time it was rented. So they actually looked at the number of days the property had been rented. Jumping to customary, It's obvious that accessory use is subordinate, but here the judge also suggested that the term incidental should be considered distinct from customary. So Ward 2 stands for the proposition that an accessory use must be evaluated on 3 prongs. It must be subordinate, customary, and incidental in that it is related to the principal use. As Michael said in his presentation, whether it's statutes or local zoning bylaws or ordinances, words are important, which explains why zoning bylaws are often constantly being updated and clarified. Here, Judge Vey opined that incidental incorporates 2 concepts, that the use is not the primary use, but rather one that is subordinate and minor in significance, but also when used to describe an accessory use, it must incorporate a reasonable relationship with the primary use. It must be attendant and concomitant. To ignore this aspect of incidental, the court said, would be to permit any use which is not primary, no matter how unrelated to the primary use. Applying the 3 prongs of the accessory use test, the judge found that in this instance, quantitatively, the Grapes rental rights were subordinate to the owner use, including vacant nights, that the seasonal rentals of residential properties have been a customary use over the years, both at this property and in Nantucket in general. However, the facts failed the incidental test, as the Grapes' primary residential use has no connection to their short-term rental other than a financial one. The short-term rental does not enhance or further the primary residence. In June 2025, the Land Court issued its decision in Ward 2 that found that the Grapes' short-term rentals were not a lawful accessory use, effectively solidifying the prohibition on most short-term rental activity under the current bylaws. The judge took a view, he's here on the right, of the Grape property. And ultimately, the result is that limiting the availability of short-term rentals in these tourist-type communities could have negative impacts on small business that rely on tourism, that in turn support local residents through income and jobs. The decision created much uncertainty in Nantucket by others with short-term rental contracts, both current and proposed future contracts. The town actually put up a Q&A page to help respond to comments. But ultimately, the parties agreed to pause enforcement of the judge's ruling to forestall immediate impacts on existing contracts, while Nantucket seeks appellate review. So one would ask, will the town seek to further amend its zoning to permit short-term rentals with or without more stringent regulation? But then, while awaiting appeal, on September 17th, almost 300 residents filed a petitioner's article to amend the zoning to allow short-term rentals as an allowable use and forcing a special town meeting. The article passed its special town meeting on November 4th, rendering the Land Court decision moot. And on November 10th, 2025, the appeals court dismissed the case. Since the original case was filed in 2023, Nantucket has introduced short-term rental registration and licensing system. It appears that in New England states, cities and towns are paying more attention to regulating short-term rentals. In addition, some states require registration of the rentals and payment of a fee, and are also collecting a hotel tax. Your handouts include a comparison chart of Mass, Connecticut, and Rhode Island, and links to additional materials. I actually had a few more slides, but I was assuming I was going to run out of time. But Bristol, Rhode Island has some unique regulations. Providence has actually done a flow chart to help people understand. And then I had done, these are all in the printed materials that'll be circulated. But we've got
minute. Pam, take another minute. And one more minute.
All right, well, let me go back to Bristol then. I found this one interesting because it really brought in some planning concepts is we're always trying to make sure we're balancing the interests. So Bristol adopted a new regulation in the summer of 2023 that specifically recognized the potential conflicts of short-term renters in residential neighborhoods while also acknowledging the opportunity for owners and visitors, with a goal to level the playing field for all involved. And then, as I mentioned, Providence has a flow chart. Since I have a minute, Bristol called out supporting the economic opportunity created by short-term rentals, creating the level playing field, ensuring the sufficient collection of tax revenue, and then mitigating the disruptive effects of unmonitored short-term rentals. So they actually have a monitoring program, and ultimately to protect the livability and quality of life in the town of Bristol's residential neighborhoods. I picked this one because my son lives there, but thank you, and glad to be here.
And now we'll move on to Marjorie Shansky. The panelists are so disciplined. Thank you very much for staying on time. Take a look at the Q&A. We got a couple of Q&A questions we want to answer along the way when we get there. It looks like we'll have 3 minutes or so at the end. Take your slide down now.
I'm trying to find it.
Yeah, well, it's up at the top somewhere.
Yeah, I'm not looking. Oh, here we go. Let me look at it.
And Marjorie,
Hello.
come on.
I can't share.
Can the host unshare me? Because I had it before, but I am having trouble finding it. Let's see. Zoom.
Ron, can you?
I apologize.
There's somebody's calendar.
I'm looking at yeah,
Yep.
that's my calendar.
Yeah.
Sorry about that.
Yep, I'll check to see if I could do it on my end. 1 second here.
I'm looking at all the speakers, but I'm not looking at the full Zoom screen for some reason. Oh wait, maybe I can hear. Screen share meeting. Nope, not leaving the webinar. We were doing so good.
Yeah.
If I don't
Oh wait,
see
I
here.
think I got it. Let's see. Share. No. All right.
It
I
says,
think I'm off
to the right
actually.
of share, it says stop sharing.
Yeah.
It's the red button that says stop
Zoom.
share.
Yeah, mine shows it's not sharing anymore though.
All right, Pamela, why don't you
Near the
drop
top.
off and zoom back in?
Will do.
Bye. We'll see
Bye.
you soon. Marjorie, the coast is clear.
Thank you. Good afternoon. I have focused on Connecticut cases, and all of them have come out this month and are of specific concern or interest because of the the nature of the decisions. The first one is an appellate court case called Sargent versus the Zoning Board of Appeals of Fairfield. And it emanates from an appeal of the issuance of a certificate of zoning compliance that signed off on a redesigned house that had been approved for a variance many years earlier, and after amendments to the zoning regulations had been adopted. And the facts are quite important. This variance was granted in 2011 that permitted a height variance of essentially 1.33 feet more than the 30 feet permitted in the zoning district for 128 square feet that provided a landing to access the roof on this flat roof design. Because of the intervening circumstances of our big storms in 2011 and 2012, the owners did not proceed to construction immediately, and then in the interim, regulations were changed that were responsive to the FEMA concerns that came up about elevation and flood prevention everywhere in each of our states. So in 2019, 8 years later, the owners changed the design and came back to get a permit to build this new house that had some additional roof issues. And the zoning enforcement officer signed off on the revised plans that permitted additional height that was, of course, a function of base flood elevation and the FEMA rules, but included a bonus 1.33 feet that were reflective of the 2011 variance. The neighbor appealed and claimed that the conditions of the 2011 variance were violated by giving this additional height to the owners, and also argued that the amendment of the regulations increasing the height effectively had mooted the 2011 variance. So it's an interesting decision by the Connecticut Appellate Court, who affirmed the trial court as sustaining or dismissing the challenge to the zoning enforcement officer's sign off. And it's an interesting discussion about the interpretation of conditions and variances. And for Connecticut people who are familiar with the Anatra case in Madison, that has been an important case in reflecting that a variance is really a function of the request that's been made. It's not, a variance does not alter the regulations in a global way. It provides for relief of the nature that has been described in the variance application. And Anatra emphasized that outcome, that the incursion into a required setback is limited to what had been approved by the zoning board. But under Sargent, the court looked at the fact that there were no conditions associated with the approval, and that the earlier height variance effectively created a new dimensional standard that was unlimited in scope, so that the plan that was approved in 2019 that had almost 500 square feet that exceeded the height restriction, that didn't matter. And this is quite a change from conventional, in my experience, in my long, perhaps too long experience. This has really changed the model for what the significance of a variance or the scope of variance was. I found it to be a decision that undermined my sense of confidence about what I know about variances. So a petition for certification has been filed with the Connecticut Supreme Court last week. And if the Supreme Court should review it and sort of restore what we understand to be the scope of a variance, which is pretty much limited to what has been requested, it seems to me that in the interim, to avoid this sort of expansion or this liberal view of what a variance gives to a property owner, that decisions might appropriately consider referencing the specific application to which the relief is appended, or the map that reflects the relief that is appended, in order to limit the scope of the relief if others attempt to interpret its significance. So Sargent, an important case to look at, I think, though its effect may be temporary or it could be permanent. The second case is a High Watch Recovery Center case. This is the fifth or sixth appeal that bears a caption starting with High Watch Recovery Center. They are a nonprofit substance abuse treatment facility who, in this case, appealed from a decision of the Department of Public Health that approved the certificate of need for, let us say, a competing nonprofit substance abuse treatment facility that wanted to establish itself in the same town. The High Watch, the defendant filed a motion to dismiss, which was granted by the court and affirmed by the appellate court. And the basis for the motion to dismiss was that the settlement agreement from which they were appealing, High Watch was appealing, was not a final decision for purposes of establishing appellate jurisdiction. And they had a second prong, which was that High Watch was not aggrieved. But all of these actions at the appellate court didn't reach the second issue. So that on remand, there generated the second appeal to look at the issue of whether High Watch was aggrieved and had standing to contest the Department of Public Health decision approving the competitor certificate of need. And that's important because there's a discussion in this case about competition serving as, or whether or not competition serves as a basis for standing. It certainly doesn't stand for a basis for statutory standing in a zoning appeal, but nor did it come to a level of being sufficient for classical aggrievement, which is the older, more complicated way of achieving standing in court. They also relied on their intervenor status at the administrative level, and this led to the court construing the statutes pursuant to which high watch was recovery and distinguishing cases in which the statute provided for an appeal by an intervenor and the case in this issue which did not provide for an appeal by an intervenor. And the Supreme Court concluded, or the appellate court on remand concluded, that indeed High Watch Recovery Center did not have standing to bring this appeal. So I assume there will be more High Watch cases, but this is an interesting case to look at because it talks about standing and aggrievement in administrative processes, which are not the same as, but closely related to zoning appeals. And it talks about the zone of interest for purposes of describing who statutes are trying to protect in providing for access to the courts. And in this case, the fact of the settlement that led to the outcome was not an issue of fundamental fairness necessary to establish classical aggrievement. So this is a largely procedural case, but these are issues that come up again and again, and therefore have merit to evaluate. This final case is a Superior Court case, happens to be my case, and it was an appeal of a denial of a special permit, which the court sustained and ordered the issuance of the special permit. This was for a self-storage facility in the town of Old Lyme. This is a not usual outcome for cases for administrative appeals because of the concept that Attorney McGregor was discussing, which is deference. There's a high degree of deference to agency decisions. And in this case, the applicant had applied itself to making a deep record demonstrating compliance with the special permit criteria, coastal site plan criteria, and the regulations themselves had a very strict and very expansive sort of narrative on the various standards that needed to be achieved in establishing eligibility for a special permit. The commission ultimately voted 3-2 to deny the special permit. And when the court looked at it, they determined that there wasn't substantial evidence to support the denial because the commission relied on general statements. I think the operative antidote is looking again at Riverbend and 3 levels to look at what constitutes substantial evidence, not concerns, but actual evidence. And in this case, for one example, they relied heavily on a fire marshal note that said he did not support the application. Court called that arbitrary because there was nothing in the regulations that required the fire marshal to comment in connection with a special permit application. So what I see this as is a message that our efforts at commissioner education continue to be of the utmost importance, because a commission should understand what the scope of their jurisdiction is and what the tools are with which they can work in finding a legitimate, non-arbitrary way to issue a decision that is in line with the protection they want to afford the town. Then in the materials, you will find reference to other cases, again, all of which came out in November. And I call your attention to the McGonigal case in Griswold Wetlands, which highlights the distinction between the latitude that a Wetlands Commission has in evaluating a cease and desist order or a notice of violation, as opposed to even a after the fact permit or an actual permit, and that the issue of adverse impact is not an issue.
Okay.
The conduct is an issue. And with that, Captain, I turn it back to you.
All right, so we got 1 minute left. We've answered a couple of questions that came in. One of them had to do with demolition, and Connecticut statute gives some latitude to a property owner, but as Michael answered in his response, it was the local regulations. Goes back to what we've heard from several of you today, is that regulations count. And on your point about your win in Old Lyme, there was a good example of where with more articulated regulations, the commission might have had its way. So before you condition something with a discretionary approval, you better have the ammunition in the regulations in order to do that. And you need more definitive criteria. Greg, we had a question about NEPA that's in there. If you could take a look at it and respond to them, that would be great. And we are very disciplined. It's exactly 1 p.m. Eastern time. And thank you, panelists, for a great job. Just perfect. Thank you very much. And good day to all of you. And, maybe we'll try doing this every year. It's kind of fun. And have a great holiday.